we provide debt to cannabis operators who are growing or are reorganizing. And also want to mention, we're not predatory. The same rates apply to everybody. This webinar series would not be possible without the support and help of Zuber Lawler. So a big thank you to them and their dedicated staff and their stellar team of attorneys. A big shout out to Tom Zuber, the managing partner. Thanks so much for allowing this to happen. I need to give a plug to Zuber as our sponsor. Zuber Lawler is a global firm with many Fortune companies as a base, and yet they are clear-sighted futurists who excel at emerging industries and technologies such as cannabis, our favorite, psychedelics, clean tech, cryptocurrency, and artificial intelligence, just to name a few. To learn more, please see the link in the chat. Celeste, our moderator, will be putting that in the chat for you to follow up if you're interested. I'd like, before we really get into it, there it is. Check it out and you'll see for yourself. I'd like to set the intent of this webinar and frankly, the intent of the entire team and all the panelists, and that is to be able to help as many cannabis companies as we can successfully navigate the challenging business environment that we're all faced with. That's our intent, and we're here to help make that happen to the extent that we can. And today we're going to discuss how a cannabis operator can successfully orchestrate a workout with its creditors. A workout basically means that you've got some issues, shall we say, and you want to come to a new agreement with your creditors, whatever that might be. So that's going to be our topic for today. Now, we've prepared a survey that we think would be very useful for us and for you, which is Celeste is going to be sending out to you. And we'd really appreciate it if you would take a moment and answer them. That would help us out immensely to understand if our questions that we're going to present to you today are relevant, and for future webinars. That'd be great. So thank you so much for taking time to do that. Our thesis for today is pretty simple. The capital markets will not offer more equity at this time. The equity markets are pretty much shut down, particularly for negative cash flow companies. New debt, if available, will be expensive and difficult to fund given the potential for legal proceedings in a distress situation. And today we're talking about distress situations. So raising new equity in a distress situation or finding new debt capital is going to be challenging. Cannabis operators cannot, and yet cannabis operators have a lot more leverage than they may think, but they really can't overplay that hand and risk losing everything. You really want to avoid getting into a war with your creditors. You want to be transparent and cooperative as much as you can. I'm not suggesting you shouldn't get legal counsel, but you have cannabis operators have more leverage than meets the eye. Why? Because ultimately the creditors, the senior secured creditors, are not licensees. So therefore they cannot foreclose fully on the operating license. Now, they're going to have a lot of collateral agreements in place, and they're going to have a lot of rights, but they too want a friendly workout, and they too want a full recovery of their funds if possible. So while you're positioning that and having a discussion with your creditors, just be aware that cannabis operators do have some leverage, but you can't overplay that, and you've got to temper that with the reality that we are in a world of capital scarcity. Now, I've got some disclaimers here I need to make. One, the opinions expressed today are the opinions of the individuals and not of any companies associated with this broadcast. And Celeste is going to be posting the full disclaimer in the chat, so we're covered. We don't encourage the use of illegal drugs. We wanted you to consult your attorney and healthcare provider before doing so. Nothing in this presentation creates an attorney-client relationship or a fiduciary relationship of any kind. Please talk to your professionals. That's the disclaimer. And now I want to move quickly to introduce a panel so we can get to the questions. First up is Tomas Ortiz. Tomas has worked with lenders, manufacturers, distributors, and multiple large real estate transactions in workouts and bankruptcies. Tomas, welcome. Good morning.
Good morning and good afternoon, everybody.
Yeah, thanks. Give us a quick 30-second synopsis of your career and how you ended up in cannabis, please.
Sure. Well, really quickly, I've got 25 plus years experience as a litigator. The bulk of my practice over those 25 years has been in commercial, real estate, and bankruptcy sectors. Strangely enough, it's the latter that brought me to cannabis. I began working with cannabis businesses and stakeholders, using my experience in bankruptcy to navigate through a world that does not have bankruptcy. I've worked on non-bankruptcy options, both in liquidations and restructurings in cannabis, as well as the purchase and sale of distressed assets, working as both transactional and litigation counsel.
Great. Thank you. Well, we're glad to have you here today.
Thank
Up
you.
next is Phil Valvardi with Global Go. Global Go is a large national cannabis consulting company. Phil has served in many C-suite roles in his career in the technology and finance space, including a stint with Core States Financial Corp, one of my old employers. Phil, welcome to the panel. And also, I think you're a Philadelphia boy. Am I right about that?
That is correct. Yes. So it's Phil from Philly.
As am I, at my hometown.
And I am actually sitting in right outside of Philadelphia as we speak. And thanks for the intro, Peter. And I have a long history in financial services, primarily banking originally, and then financial technology. So very used to operating in highly regulated spaces. And while I've been, somewhat of a cannabis enthusiast my whole life, not until about 5 years ago did I actually enter the space full time. And that was largely because incredibly conservative, risk-adverse banker that I was working with had gone into the cannabis space, and I was kind of shocked. And as I looked into it, really just saw the need for people like us to participate in the space and really help grow and expand the space. And so I'm really happy to be part of it. It's some challenges lately, but I do think the long-term prognosis is still very positive, and we've just got to get through some of these bumpy roads ahead of us right now.
Well, yeah, that's great. Well, thank you. Thank you. Up next is Kyle Everett. Now, Kyle has been with Development Services, Inc. for over 17 years and is currently the Senior Managing Director in the San Francisco office. DSI, as it's lovingly called, provides many, many different types of fiduciary services, restructuring, corporate finance, forensic accounting, litigation support, and expert testimony, all of which is needed if you need somebody like that on your team if you're going to go into a workout or a reorg. So, Kyle, do you want to add anything? And
Sure.
How did you end up in the cannabis game?
It's from other people in the firm that have wanted to break into the arena, and we've been kind of dipping our toe in for the possibility of assignments for the benefit of creditors. I've done over the course of my career, kind of cradle to grave. I started out doing traditional accounting work, a lot of public companies, and now I'm kind of at the end of the career, the graveside. I do a lot of wind downs, but over the course of my career, I've done an enormous amount of workouts, and I just thought that it would be interesting to see how mostly receiverships would fit into a cannabis situation. I've done a lot of receiverships. So, and just as a fun fact, although I don't cook with them with cannabis, I am a phenomenal amateur cook. So.
Well, good to know.
Yeah, well, just some personal thing.
Yeah, that's great. Up next is Josephine Giordano with Beach Fleischman. Josephine, good morning.
Good morning.
Nice to see you. Yeah. So Beach Fleischman is one of the top 200 CPA firms located in the Phoenix area with 7,100 clients. Josephine is the Senior Director of Financial Forensics. That's a formidable 2 words, financial forensics and business valuations. And she's the National Cannabis Practice Leader. So how did you become the National Cannabis Practice Leader?
Well, I've been in consulting for most of my career, and when I moved over to Beach Fleischman, about 3 years ago. I had already been within the cannabis industry prior to that, doing forensic work and some merger and acquisition work, and realized that the industry was in desperate need of really good tax people, audit professionals, as well as consulting professionals. So I transitioned over to Beach Fleischman, which is Arizona's largest locally owned CPA firm. And we've got clients all over the country in Canada and Mexico. And there built the practice, and we have a phenomenal group of professionals who specialize in the cannabis sector, from tax to audit, and for myself, consulting and reorg and turnaround services, as well as business valuation services.
Wow. Well, great. Welcome. We're really glad to have you, Josephine. Thank you.
Thank you.
Welcome. And so let's reiterate the theme here. So we don't want to get really down in the technical weeds. So we framed a hypothetical kind of outline, and we're going to explore the world of a cannabis operator who has enough working capital to get him through the end of 2023. That doesn't mean we can't talk about other things and more urgent matters, but we just want to set up a discussion where there is time to thoughtfully put in a reorganization plan and thoughtfully have dialogue with creditors, and it's not the house burning down. And with 9 months and the right team, it's highly conceivable that you could come up with a plan to become positive cash flow within that time period, and that's really what we're focused on. And so here we go with a question. So the first question, and this is for Josephine, is what is the most important tool or tools to manage a successful workout, to manage a successful reorganization?
So I would say the concept of reorganization, and as Tomas had mentioned earlier, I've also worked in the bankruptcy sector, and a lot of the tools that we use within bankruptcy, although it's not applicable in cannabis, is relevant within the cannabis industry. So I would say in any type of reorg plan or any type of turnaround process for a distressed business, I mean, to me, the key is obviously having the legal and financial professionals involved right from the start. To have a successful plan, it's really important from my perspective as a CPA and a financial advisor to ensure that the company's books and records are, number one, accurate, and information is getting reported timely. So that's key. One of the first things I do when I walk in from a financial standpoint is putting together a cash flow forecast. You would really be surprised how a lot of businesses, in particular, companies operating in the cannabis sector, do not really operate with a cash flow forecast and budget, to really understand where they're at and where they're going. Because if they're already in that distressed situation, now they probably have debt that's in default. They have to build that into their model and really determine at what points in their forecast are they really going to hit, really severe deficiency levels. And at that point, you're planning for what needs to be done in terms of any type of injection of capital and or debt in order to operate this business and get them to reorganize. I would say in general, from a high level, the tone at the top is key, making sure that the group wants to work with you and they want to turn it around and they want to reorganize, having them be transparent with their legal and financial professionals with respect to what happened in the past and what they intend to work out going forward is important. So that transparency, the accountability, putting people in charge of different things within the reorg process to make sure people are accountable for what needs to be done. So I think that combination of transparency, accountability, financial reporting being accurate and timely, and cash flow forecasting is key to a successful reorg plan.
Oh, great. So here, this is a question for the panel. Anybody can jump on this. So how any company may or may not be positive cash flow when they realize they've got a problem, but how important is it to be or become positive cash flow, and how off the mark? I mean, how big a hole is it realistic to dig out of to get to positive cash flow before it becomes unrealistic? So it's really a two-part question for the panel. How important is it to achieve cash flow, and how close does that goal need to be in order to be a candidate for a successful reorg? Anybody? Phil?
Sure, I'd be happy to. I mean, I don't think there's one size that fits all, quite frankly, because it really, depends on the segment you're in, the nature of the business, lots of factors. But I do think it's important to have that plan to positive cash flow that, your investors, your creditors, those people can look at and feel like they have a level of confidence that it's achievable. So I think having that, very specific plan and some action steps and metrics on how you're going to measure, the milestones. Obviously, cash itself is a big milestone, but you have facilities. Take for example like a cultivation facility, and maybe it was initially a pretty large capital lift, and you knew it was going to, require more cash to eventually get a positive cash flow. That's a lot different than maybe a dispensary where you thought you'd get the positive cash flow in 3 months. So I think it really just depends on, the specifics of the business. But I think the real message is, having that path to a positive cash flow that you can demonstrate to either a creditor or investor or wherever you need that support to keep the business going.
I echo what you said, as well as what Josephine said, and that is credibility. If the lender you have to have credibility with the lender to make sure that they understand that you're on top of the problem. The biggest issues in workouts that I see are when the lenders don't have confidence in what management is doing. So management has to be confident that they've taken the steps that they need to take, that they've planned as best they can. This is an unfortunate circumstance or something that they didn't plan for, and they can just be, as has been said, open and honest about what the solutions might be. It's really going to be developing a relationship with the lender.
And Kyle, just to quickly add on to what you just said, that lack of credibility or that lack of confidence is what ultimately does result in, let's say, a receivership, setting. So you really want to build that and communicate to your lender.
Exactly.
Tomas, any quick thoughts?
No, I mean, I think we're going to be talking about approaches with regards to creditors a little later on, but
Yeah.
I echo everyone's position on this. And I think what you're going to hear a lot of in this, in our talks today is communication and transparency. I think that's key on all grounds.
Well, great, thanks. So Phil, what in your experience, what are some of the common triggers that precipitate a crisis? Let's use that word in a broader sense, or a realization that action needs to be taken. What are some of those triggers that you've seen in the real world?
Well, so we've done work all over the U.S. and of course we have affiliates in 9 countries. So we've seen a lot, and I would say it's a combination of like controllable and uncontrollable factors. And like on the uncontrollable side, there are things that, economic conditions, regulatory changes. You're a cultivator in California, and because of what's happened on the or lack of regulation or lack of enforcement, maybe. You're in a situation now where it's been a race to the bottom recently, and it's really hard to compete in that kind of environment for a cultivator. So there are, those somewhat uncontrollable factors. We actually had a client in Ukraine, of all places, trying to stand up. This is an extreme example, but trying to stand up a cultivation and manufacturing facility, and halfway through, the war came about. Of course, that project didn't go forward, but there are things like that are out of your control. But typically, if you're communicating well with your investors and lenders, those things are probably a little bit easier for them to understand. There are also some competitive things you can't always control, which are a result sometimes of regulation. You know, if a certain jurisdiction allows more dispensaries than is really needed, you know, those types of things you can't always control. But I will say to me, the number one thing that precipitates this financial crisis is usually not really closely watching your cash flow. I mean, if it's something controllable, it's really that cash flow. You know, everybody says cash is king, but it really is. And it's a combination of that. And I also feel, and I think Kyle and others touched on this, is the communications, that if you are effectively communicating with your investors and debtors, at least there won't be any surprises. There shouldn't be any major surprises as things happen. And I think they're more inclined to work with you if you've been communicating all along. And of course, that you have a clear path and, you know, some detail around that path to get out of the current situation that you're in. You know, there's nothing. I mean, I've been involved in a couple situations. One where I had to take over a company that was in distress, and you know, it was a bunch of VCs that brought me in, and I wound up liking all of them but one. But you know, even that one that I really disliked immensely, I built a pretty solid relationship with them because I knew, you know, you can have one debtor or one investor that you don't have a good relationship with, and they can crater your whole business. So I think, you know, it's a soft skill, I guess. It's not, you know, very specific, but, you know, having that specificity around the relationship and providing information, I think is really important.
Any other thoughts, folks?
And if we're talking about triggers, and I'm the lawyer here, so I'll talk about litigation being huge.
Yes.
And I mean, it doesn't always have to be the big creditors on the board or the big stakeholders on the board. It could be as simple as a vendor that can completely shut down a business through a lawsuit. And you know, we'll talk about this maybe a little bit more in depth a little later on. But you know, unfortunately, we don't have bankruptcy. We don't have the automatic stay or, you know, the legal timeout to keep everybody at bay. And so it does become there is an issue when creditors decide to to race to the courthouse to try to see what they can do, and that could undercut a business. And ultimately, when we're talking about a workout, it can undercut a workout. So. But yeah, for me, litigation, and again, we're talking about whether it's a vendor or a stakeholder or a landlord. And from the bankruptcy context, I've always felt that bankruptcies are tied to foreclosures and to unlawful detainers. So when a business is threatened, its place of business is threatened, that's when you start seeing businesses really unraveling, and why they seek bankruptcy. In cannabis, unfortunately, you don't have bankruptcy, so it becomes another issue, but I'd say litigation is a big one.
I agree with that, along with the lease issues and tax problems adding into that. But I think that those all fall under what Phil had talked about as controllable issues. It's if the company doesn't have control and perspective of what their cash flow is, that I think is problematic. And, you know, when Josephine said first thing was when she goes into a company is do a cash flow, I would say that the companies ought to be doing those things now, not when there's a problem, so that they can anticipate the problem rather than react to it.
Great, thanks. Tomas, on the tail end of your comments, let us hope that everybody stays calm, but what posture can a cannabis entrepreneur adopt to keep everybody calm and avoid the race to the courthouse, which would give some foundation to build a successful turnaround?
Yeah.
You know, should they hire an attorney just in case, or how does one build a team in that regard?
Well, I mean, let me look at that going backwards, forwards. Let me take that sort of backwards, and we're looking at the goal. And I view success in the context of restructuring or turnaround. It's continued operation, and you can color that a bit, whether it's survival plus, that is emerging out of the process in a better financial position, and maybe not just kicking the can down the road a bit, but success is fundamentally continued operations. It's about getting cash flow, making sure that more comes in than goes out, and keeping that front door open. In a workout, as opposed to other restructuring processes, there's no formal legal framework, no statute, no court oversight, no intervention. So, and no automatic stay, as we've discussed. So, a workout is a negotiated settlement, and you are trying to settle and negotiate it while the world around you is operating at full speed. So, your posture with your creditors should be one of negotiation. What can I do to get them collectively on board with this? Because that's the only way the business is going to operate. It's the only way that you're going to have a successful turnaround. And in that line of thinking, operation is key. And we sort of discussed this at the very beginning. Operation is not only the goal, it's really the leverage here, and for a cannabis business. Folks may disagree, and my approach has always been that the business value is in its operation, particularly in the cannabis sector, which is so highly regulated. Unlike business, unlike other industries, there are issues that in regulations that take effect. So unless the business has or owns real estate or has machinery or vehicles, which it usually does not, usually those things are leased, there's not a lot there for a creditor to come in and foreclose or attach to pay off its debt. So again, you add the regulatory complexities depending on the jurisdiction. Cannabis collateral is not easy collateral. Inventory is not easy inventory. Licenses are not easy. But those are, funny enough, usually the most valuable assets that a business has. And that value is generally premised on ongoing operations. So the leverage here is that it's in everybody's best interest financially that you keep operating. There's no real glory in the race to the courthouse or the courthouse steps. So communication is key, and the operator needs to approach creditors with that in mind. Communicate its value as an operating business, particularly in that regulatory environment, I should say. Communicate with your stakeholders, creditors, lenders, and early communication. We talked about having that communication from the very beginning is key. Bring them on board early, have them become part of the process. And ultimately, effective communication requires planning. We talked about the collective. Who do I need to get on board? Who's skittish? Who's threatened lawsuits? Who can ensure that I can keep operating, get cash moving in, and hold off from cash going out? And set up a plan, a structure for restructuring. That's key.
Well, great. Thanks, Tomas. And going back to something Phil said about having the soft skill to create a solid, trusting relationship with someone who you may not particularly care for. And Kyle, with all your experience in all these situations, my question is, if things do get tense and edgy and people start going for their pens to sign the retainer agreement to file a lawsuit, what tools can you use to kind of cool things down, back things off, get people back at the table and calm?
I think it starts with what we've talked about before, and that is the level of confidence, having a plan, being open and honest with the lender, constantly stressing that this is a mutual beneficial situation that you're trying to work out, having an open mind. One thing I wanted to mention, in a case I just the other day got involved in, the company it isn't a cannabis company, but it's a workout situation, and they're having cash flow crunches. And I was asked to reach out to one of the landlords, and I did. And I didn't know it at the time, but I just told them everything that was happening, and they got a bunch of other people on the phone. Turns out that they have a distressed lending aspect to them. They're not just a landlord, and they wanted to know how they could help. Could they lend money? I told them that we had hired somebody to try to market and try to get us money, equity or debt, and they wanted to know how they could help. They wanted to be viewed as a partner. So, if you appeal to the lender or the investor, mutual agreement or mutual beneficial outcome, then I think that's going to be very helpful. I think you have to do it in a calm manner. Again, I think you have to have confidence in what the problem is. I think you have to tell them the solutions that you've potentially seen and why they didn't work. They may have a different perspective on what the solutions are. They may have a different attitude about why something doesn't work and why something would work. So don't just discard the things that you've tried and haven't been successful at. Let them know that you've tried. Keep an open mind to what they want to suggest. They're probably going to want some heightened reporting.
So in other words, even though the situation might be tense, be open to any creative idea that might lead to a solution.
Yes.
So, all right. So in that, sub questions of the same topic for you, Kyle, and the whole panel is, what types of demands might a cannabis operator hear from the creditors at the front end of this conversation? And what protections should a cannabis operator consider without getting, pugilistic, going into the early stage of negotiations? Is there an ideal legal stance, and what issues are the creditors likely going to put on the table, or demands? Can those be anticipated?
I'll let Thomas talk about the legal part of it, but I think that people are going to want more information. They're going to want to understand what the problem is. And the more you know what the problem is and can tell them up front, I think that's going to be very, very helpful. I think you need to have, as Josephina said before, a budget, a cash flow projection, a rolling 13-week cash flow projection, budget to actual with explanations, key metrics, and why something happened and why something didn't happen. And I said, plans to fix the problems, and then a proposal for solutions. And I do think that, you don't want to Bigfoot somebody, and you don't want to start out difficult, but I do think that legal counsel, legal representation is important in the early meetings. There are opportunities, there are, like I said, receiverships that you could put the company in, but I think that those are last steps. But I think the most important thing is to try to keep the company on a communication and open, honest footing with the lenders.
I mean, sometimes it goes back to the simple concept of having your books and records complete and submitted to them, because a lot of times companies get into this situation because their accounting records aren't timely. They're not properly reporting or accurately reporting. So the lenders are wondering, what's the financial condition here? Where did the money go? How was it spent? So they're in the dark, and they need, going back to your confidence and transparency concept. I mean, they need to see those financials and know that they're something they can rely upon. I mean, it's used in bankruptcy for cash collateral. I mean, how is cash being monitored, spent? And they'll allow that based on the transparency of the information.
And again, if you've tried to cut costs, tell them that what costs you cut. Tell them what measures you've already taken. Nobody likes to have, no lender likes a company to come to them and have them have to suggest all the things that they should have been doing. Do the easy stuff first.
Amen.
I think
Bill,
that
or Thomas.
Sorry.
No, go ahead, Thomas.
The other thing you got to keep in mind is that sometimes communication and transparency may not be enough, and you might get creditors who want control. They want to have somebody at the table involved in the decision-making, whether that's day-to-day or whether that it's the larger context, that certain decisions need to be run by somebody that's associated with the creditor. Creditors may decide to bring in a third party, a restructuring officer, as it were, or the CROs, to come in and, in essence, handle the restructuring part of it as a trustee would in bankruptcy context or a receiver in the receivership. So those are asks that might come down the line, particularly depending on where the business is at. And, you know, our scenario here is that it's early in the process, but maybe things don't exactly work out towards it. And so they might get, the asks might get a little bit more. And that would be something that a business, the cannabis business may not necessarily be comfortable with, but that might be something that needs to happen in order to keep the workout deal in place, and then also to keep the business running and moving forward.
Well, Tomas, it's a very good point to what you said earlier, and that is that oftentimes it's a junior accreditor that gets a burr under their saddle and then threatens to file action. So do you see it if such a liaison, I'll use that word, a senior credit officer, senior restructuring officer liaison is created, is that not a productive way to communicate collectively to the creditors as a group, the junior, senior, landlord, et cetera?
Yeah, I mean, that would be. Look, one of the problems we have here when we're talking about, say, for example, junior creditors or these or vendors maybe, those are the folks that are usually hit the hardest in these scenarios. And they're usually the folks that get ignored and get unaddressed and then cause problems. And we talked about that with regards to litigation, that it's not the big stakeholders that file these lawsuits. It's the vendor that's owed, who's 3 or 4 months behind and doesn't feel as though they're being heard or listened to, or are really concerned that the business is going under. So they want to get their first shot at attaching something or getting some documents. So yeah, I think that communications board and the feeling that they're being part of the process. And so that's part of the communication process, right? And so they may feel as though they don't want to be pushed out by the larger creditors or the stakeholders. And so that third party overlord, for lack of a better word, the CRO to come in might provide some sense of, okay, at least I'm going to be heard. That requires planning, and we keep talking about communication. We also want to talk about planning. It requires a structure. It can, and we've talked about borrowing from the bankruptcy line of thinking. Organize who your creditors are, vendors. Consider, who's critical to the business moving forward, and how are we going to address their needs, and how are we going to pay them up. Categorize folks. And then communicate what you're going to do with those particular vendors, with those particular creditors. Let them know what your intent is on moving forward. And so that will usually address those issues that can sometimes undercut a workout, which is usually a lawsuit that comes down.
Great, thanks.
I think, let me just jump in for a second. The use of, these situations get very emotional, and it's hard for the company and the creditors to stay unemotional. So I think one of the first things that you need to do is get somebody, an independent consultant in there who doesn't have a stake and isn't emotional about the situation, especially if you're dealing with unsecured creditors. One of the things I've done in the past is put together for unsecured creditors as opposed to secured lenders, a very simple analysis that shows if we ended up, in a liquidation situation, what would they get? And it kind of helps to drive the point home that, mutually assured disruption is exactly that.
Yes, and the panel, let me take a moment here. We got a great question from Max Mossner in the Q&A, which we'll get to at the end, but I just wanted to take this opportunity to let the participants know that we will be addressing your questions. And so please put them in the chat or the Q&A box, either one. Thanks, Kyle. Phil, any other thoughts on rebuilding trust that may have been lost?
I think we've talked a lot about, the establishing credibility, obviously, or reestablishing credibility, cash reporting and cash control. I think we may get into it anyway, but if we didn't, I did want to bring up the fact that there are, typically cannabis businesses have multiple assets, not just hard equipment assets, but license assets. And so I think it's important for the operator to understand, what their inventory of assets are, and what the potential value of those could be, and what the capability would be to sell some of those assets, and how difficult that process would be, and how would they prioritize it before a creditor comes in and wants to prioritize it for them. But I think if they've done that, inventory of their assets, and what could be potentially disposed of, and that may be a plan or a plan B they have in their pocket that they can communicate with the groups that their debtors or other groups that they need to basically show that they have a plan. Because sometimes it may not be enough just to be able to prove you have a path to positive cash flow, or maybe you can't easily do that, but you might be able to get there through disposing of some of your assets.
Phil, you raised a really good point. In a lot of the cases I've worked on, the companies were seeded with a big chunk of capital up front, and they had big plans, and they got lots of licenses, perhaps in multiple states, and they were not able to implement, or only partially implemented, the business plan behind each license. So I have experienced myself that there are loads of licenses that they are unable to sufficiently nurture and cultivate and grow. So if that is a source of value, that's certainly one can see that would bring creditors to the table. So I want to explore that a little bit more, but I also wanted to throw this one out to Josephine, which is a little bit different. If there are tax liens or past taxes due, which is not infrequent, how do you manage those relationships as to compared to the normal creditors?
Well, and it is very common, actually, that's lack of payment, on taxes has been an issue that leads to the distress, because we all know that from a cash flow standpoint, that the tax burden, is pretty large for companies in this sector. The key in the cash flow forecasting, and this is the problem I've encountered many times, is that certain companies have not paid their tax debt in many years. So that principal amount has, maybe even doubled from when they started, between, interest and penalties. They keep compounding the burden that's associated with that tax debt, and then the liens that are associated with it. So first, it's important to identify what's actually owed. If you're in negotiations with the IRS and discussing, any type of settlement on these amounts, where are we with that? I mean, I've encountered companies who don't even really know where they're at in that process in their communications with the IRS. Just working through that, building that into your cash flow model. I mean, that's one of the biggest struggles I have, is just figuring out what's happened before and getting that built into the model so that we can project going forward. And that's all coming from, management. So they've got to have a real tight handle on that, and cooperating with the IRS and being able to support their positions. The key to issues with 280E and, is one thing, not paying your taxes is another, but, just being able to support the position that you're in and be able to accurately forecast what you can afford to pay, and if that's something that the IRS will work with you on.
Well, great, thanks. We've got, just to remind all of us, we got about 5 more minutes in panel discussion, then we're going to go to Q&A. Here's a question that I'd like to throw out, kind of jumping ahead. Is it when a operator realizes that they need to make some hard decisions, is it realistic to imagine approaching a larger synergistic partner who perhaps is hopefully better capitalized, in order to enlist them? I mean, is that practical? Is that realistic for a smaller player to approach a larger, more successful organization to seek an alliance?
I think
Bill, you want to give that a go?
Oh, I'm happy to. I think it's realistic, although the current environment, is certainly difficult, but it's part of it is being prepared for that conversation. So all the things we've already talked about here, you need to make sure you're prepared. And I think part of it is demonstrating that you have an asset. It doesn't always necessarily have to be an asset that has a lot of value on paper. It could be you have, if you're an ancillary company in the business, or even if you're a manufacturer, you may have some, technology that is of value to that larger partner that they don't have today, or just a way of growing, or a way of processing, or maybe it's, something on the back end that you do. So I think all those things are possible, but to me, it's really important to have a very clear understanding of your own business and the assets that would be attractive to that partner, and making sure that you can build a really strong case around those assets, and it's not perceived as an act of desperation. Even though you certainly will, you need the cash, or you need a partner to kind of help you through a difficult period. I think it's really important to have that detail, the value of the asset, maybe the intangible value of the assets that you have, metrics to support your case. Obviously, the cash flow and financials, you should have those in order as well. And also, be really flexible, because you're probably, by going to someone like that, they will certainly perceive you're not dealing from a position of strength. But at the same time, if you approach it calmly, and you have all these tools, and you have, some good advisors, and you've done the right work on the, financial and legal side in terms of the advice you're getting, you could have a good conversation there. But my strongest piece of advice there would be not to wait till the last minute. I mean, typically you have a good sense of where you are. I mean, if you're running a company, and the idea is, negotiate before you can't, because at some point you'll get in a position where you don't have much negotiating power. So, having the ability to see that early, even if it's not the greatest decision and you're not really enthusiastic about it, at some point in time, you've got to do what's best for the business, for your investors, for your employees, and look at those options.
So I would summarize that stance as being, don't perceive yourself as going to someone, a strategic partner with hat in hand. Go to them with a proposal, a workable proposal, and be realistic about the relative strength of your companies.
When also, if you have any insight as to their metrics, or even assumptions about what their business looks like, showing them what the synergistic effects could be.
Yep,
that's a great point. Great point.
Yeah.
So we're almost out of time on the panel. Another great question came into the Q&A, and they're both related. So let's pivot a couple minutes early, and because these are two great questions that really get at the heart of a lot of the distress, particularly in the cultivation side. So I'm going to read the second question first, and maybe take a shot at answering it, and then let's focus on the first question. The second question is our guest wanted to know an honest assessment about how bad is it really out there, specifically with large cultivation facilities. The minority of cannabis cultivators seem to have the cash flow and the operating cash flow to meet fixed obligations this year. And really what that question illustrates is I'll use the term cannabis premium, the price that was paid for the asset, the building, and its tenant improvements greatly exceeds, I mean, by factors of 2-3 times what a normal commercial building would cost. And at $1,500-$1,800 a pound wholesale, the economics make sense. But in California and Arizona, there's stories of wholesale flower going for $400 a pound. At $400 a pound, that asset value, that was those deals that were conceived at those high cannabis premium prices, doesn't pencil any longer. And so the question is, how big a problem is this? My personal opinion is it's way bigger than anyone thinks, and it really keeps the folks at the REITs up at night around this question, and it certainly worries the cannabis cultivators. But any quick thoughts?
I agree with everything you said, Peter. Now, I will, I would parse that a little bit by market, because obviously each market is a little bit different, but we've seen, I think everybody's familiar with what's happening in California, and it's a really difficult situation for cultivators. And, I wouldn't be one to estimate, what number will be successful a year from now versus those who won't make it. But I think, sitting where we are today, unless something drastically changes, it seems like there's a high percentage of those operating today will have a difficult time operating next year. But we're seeing it, all the way across the East Coast, like to Massachusetts, which at one time, maybe 2 years ago, even was like a $4,000 a pound market, because there was a more limited license. It was early on, that wholesale prices there have crashed. So it's really, it's spreading everywhere where there's not, control on the amount of cannabis that can be produced by cultivators.
And the price compression is happening much faster.
Oh, it is. It's happening much faster. And there's a thought that if you're producing premium cannabis, those prices are still holding. But, I think generally we're seeing those prices drop, and not everyone can be a producer of premium cannabis. So, I think those companies really have a difficult time ahead of them. They should be, taking a lot of the steps that we've recommended here to take a really hard look at what they have and what the options are available to them, before they don't have any options. And, while we love to see regulations change and other things change that will make the environment better, unfortunately, I think if we're realistic, we know that's not going to happen really quickly. It just doesn't.
Right.
Yeah.
And that leads us into the second question, which is, let me read it. A majority of the cannabis operators seem to be locked into long-term sale leasebacks or long-term leases, whether it was a sale leaseback or not, at rates they can no longer afford, especially if they're forced to downsize. I mean, if they have to lay off staff to make payroll. What sort of options do operators have getting out of or renegotiating those rents before defaulting and being forced to hand over the keys? Now, that is a well-stated question. And Tomas, you might be the best person to answer that question from a legal perspective. What options does a tenant have to have rent readjust to recognize the current wholesale market?
Well, I think they've got, as you would have in any industry, obviously, the ability to go back to the landlord and try to renegotiate your lease. There are always going to be practical leverages that you can use to make that happen, particularly depending on the property and the use of the property. And those would be ways that you can go to a landlord. Look, one of the big issues that we saw, let's look at COVID, for example, even though there was a moratorium on landlords' ability to remove tenants, what we also found was that there wasn't a long line of tenants to come in for the landlord to say, okay, I'm going to hand the land over or the property over to the next person in line. And so in this case, because in a lot of cases with regards to cannabis places of business, there's a license tied to them. There is permits tied to them, both on state and local level. So those can be used as leverage to say, look, you're not going to be able to get the same deal from the next guy in line. Let's rework this out, because it's in everybody's best interest for me to stay here and take advantage of what this property has to offer, because there are those regulatory ties in. So, those are ways of dealing with it, but it does require, I think, as we keep talking about, early communication and addressing those issues early on.
Well, Tomas, you make a good point, and particularly the point that the wholesale market affects everybody. And if one tenant is evicted and the landlord wants to find another cultivator, that cultivator is going to have to deal with the same market price forces and is going to need to have its cost structure in line. And so it's quite likely that any new tenant is not going to pay the same premium that maybe was struck 3 years ago. I think that is a very compelling reality for a landlord, and how this unfolds, we'll watch quarter over quarter as REITs report and as distress begins to become apparent. But my own personal opinion is I think a landlord would want a tenant who has been performing, who does know the building. A landlord does not want to do new tenant improvement, does not want to change, does not want 6 or 8 or 9 or 12 months with no rent in a falling market. So just as with negotiating with senior secureds, there is some leverage there, but you can't overplay your hand, and you have to keep the conversations cordial.
Yeah, and unfortunately, we don't have a legal way of freezing things. And so we talked about this earlier on, which is when we're talking about the threat of eviction or the threat of foreclosure, when it deals with real estate, you have bankruptcy that's going to protect you at the tail end. That's not available here. So you do have to be careful with that, because otherwise you could just simply file for bankruptcy and have everything frozen so that you can then deal with it and address it one thing at a time. That doesn't happen in this situation.
Just as a side note, with our lenders these days, our argument is, look, there is no such thing as a cannabis premium. There are the margins in cannabis aren't there. You cannot expect to get these rates and have a portfolio of performing loans. So let's get real. For lending to a landlord is a non-plant touching business. Now that argument is falling on deaf ears to a certain extent, but nonetheless, it's real. In other words, what I'm saying is, I don't think the industry can afford to support those cannabis premiums. And I suppose this is a message to cannabis landlords, kind of heads up. One of the last things, and Kyle, you mentioned this in our last webinar, one of the last things that we want to say to everybody is, however discouraged you are, don't throw in the towel before you call somebody. Call anybody on this panel, call somebody. As Kyle mentions, a neutral third party to get an assessment of where you are and get an assessment of what it will take to reorganize and recapitalize. Now, maybe in the end, you'll decide it's not worth it, but make a call.
Right.
Call us, call somebody, get a second opinion, evaluate your options before you decide that you're just had it and you're going to walk away. Any other closing thoughts on that sentiment, panel?
Just to summarize, understand your financial position before you get into trouble. Anticipate what the problems could be, and generate a level of confidence, whether you're talking to a lessor or a lender. The same aspects apply. You need to have a plan, and you need to be able to tell them why, and not necessarily this bluntly, but tell them why they need you and they need to keep the position in place, whether it's a lease, whether it's a loan, but it's going to be better for everybody involved.
And I would say also too, I mean, you could be in, perfectly fine financial condition, but if you're not anticipating any potential legal threats and contingencies related to, any lawsuits that might be coming down the pike, that could eventually lead to stress. So just getting a handle, not just on the accounting side and the financial side, but knowing or anticipating what potential legal threats you might have, I think is really important.
So it's kind of always be prepared, the Boy Scout motto, right?
Yeah.
All right, well, we've pretty much used up our time. thank you, panelists. I really appreciate it. Thanks to the audience for taking the time of the day, and thank you so much to Zuber Lawler for making this happen. Wish everybody a good day, and